ladies and gentlemen, students and scholars, teachers and professors and professionals, listeners and learners, those who belong to medical, non-medical, commerce, arts and engineering, the most honorable President Prime Minister Narendra Modi ji, respected doctors and ministers, advocates, advertisers, administrators and advisors, reverend fathers and mothers, affectionate sons and daughters. I, Dr. Rakesh from USA, heartily, cordially welcome all of you. It is really nice time, nice place. All of you are listening the importance of celebration that is being rememorized by our President Prime Minister Narendra Modi ji, a great views and history. Subhash Chandra Bose, Netaji Subhash Chandra Bose, whose statue is recently built by our President Prime Minister with a Kartav path in the heart of India, which is a great symbol and icon of the freedom. Regarding freedom, Netaji Subhash Chandra Bose, people, we are not the beggars of freedom. Freedom is our right, and we will take the freedom. This is what that is brought in 1947. And in 1948 too, he started this movement, a great National Indian Army. He established for providing freedom to our soul, politically, socially, and even spiritually. So, dear friends, our President Prime Minister has provided recollection of our forefathers, freedom fighters, messengers of freedom, those who came on this earth for the healthy generation of our India. It is really recordable, historical, praiseworthy, admirable. For short, in praise of such personalities, dear friends, what is the law of evidence? A great evidence in the form of statue. That is the statue of freedom. In that form of evidence, we remember the importance and values of our historical, cultural, and nationalistic feelings, supreme patriotic feelings that they brought in our Indian people. The word evidence is derived from that Latin word evidence, which means to show clearly, to make plainly certain, to prove. and present Prime Minister has proved it that we are the establisher and founder of our personal spiritual freedom soul. For this nation, our spirit or soul should be free from all foundations. By paying attention on the duties, beauty is beauty and beauty is duty. It was a great message and meaning through the Kartavya path is being provided to the people. Earlier it was king's way, king's path. In place of that, our present Prime Minister has replaced by Kartavya path for remembering and recalling the importance and value of our freedom fighters. What an amazing and remarkable, surprising to make plainly certain, to prove. Thus, it signifies that which demonstrates, makes clear or ascertains the truth of every fact or point in issue, either on the one side or on the other. Again, it includes all the legal means, exclusive of more argument, which tend to prove or disprove any matter of fact, the truth of which is submitted to judicial investigations. Our judiciary also provides a system for the justice, for providing judgment and justice to our downtrodden, rejected, the poor, the needy people of our society. Likely that these are the first steps that are being taken for the rejuvenation, reoperation, reformation of our Indian society. Law of evidence is a unique piece of legislation with very few amendments since its enactment in 1872. This act is already running in its second century without much change, which proves that the provisions of the act are virtuous beyond all doubt. Thus, this act is a complete code and it dealt with all the questions of admissibility of relevant facts and other connected points. It governs the means and the manner in which a party may substantiate his own case or refuse that of his opponent. The law of evidence underlies the whole practice of law in every field capable of leading in litigation. It bears the same relation to the judicial investigation as logic to reasoning. Law may be divided into two branches, that is substantive law, which defines rights, duties, liabilities, and punishment, and adjective law, which is commonly called as procedural law. The adjective law defines the procedure, pleading, drafting and proof, etc., by which the substantive law is applied to practice. The law of evidence is an adjective or procedural law. It is the most important branch of adjective law. The object of this act is the establishment of relevant facts by proper legal means to the satisfaction of the court and include disproof. It is to legal practice what logic is to all reasoning. Therefore, without this act, trials might be infinitely prolonged to the great detriment of the public and vexation and expense of suitors. This act determines, one is, what sort of facts may be proved in order to establish the existence of that which is defined by the substantive law as conclusive. Next is, what sort of proof is to be given of those facts. Just next of it, who is to give it and how is to be given. Thus, this act means anything by which any alleged matter of the fact is either established or disproved. Again proof, apart from argument and cross-examination drawn from facts in evidence, is effected by, one is evidence, two is presumption, three is judicial notice. Lastly, the three cardinal rules of the act are, one is, evidence must be confined to the matters in issue. That means only relevant facts are to be admitted in evidence. Two is, hearsay evidence is not to be admitted. And three, in all cases, the best evidence must be given. Furthermore, the law of evidence consists of provisions upon the following subjects. One is relevance of facts, two is proof of facts, and three is production of proof of relevant facts. The law of evidence is the lex fori, which governs the courts, whether a witness is competent or not, whether a certain matter requires to be proved by writing or not, whether certain evidence proves a certain fact or not. That is to be determined by the law of the country, where the question arises, where the remedy is sought to be enforced, and where the court sits to enforce it. Again, the rules of evidence are in general the same in civil and criminal proceedings. As such, there is no difference between the rules of evidence in civil and criminal cases. If the rules prescribe the best course to get at the truth, they must be and are the same in all cases. Kinds of evidence. The Indian Evidence Act gives two kinds of evidence, such as oral and documentary evidence. In oral evidence, it means all statements which the court permits or requires to be made before it by witnesses in relation to matters of fact under inquiry. It is also the statement of witnesses before the court and oral account of the happening of facts given by those who have personally witnessed the happening of those facts. The oral evidence must in all cases be direct. Thus it seems, if it refers to a fact which could be seen, it must be evidence of a witness who says he saw it. Next is, if it refers to a fact which could be heard. It must be evidence of a witness who says he heard it. Next is, if it refers to a fact which could be perceived by any other sense or in any other manner, it must be the evidence of a witness who says he perceived it by that sense or in that manner. And next is, if it refers to an opinion or to the grounds on which that opinion is held, it must be the evidence of person who holds that opinion on those grounds. Witnesses who are examined on the plaintiff side are called plaintiff witness, and witnesses who are examined on the defendant side called as defendant's witness. Anyhow, where witnesses are examined in order to prove the case, it is based on oral evidence. If any oral evidence refers to the existence or condition of any material thing other than a document, the court may, if it thinks fit, require the production of such material thing for its inspection. Thus, if the evidence of a witness is given orally, it means oral evidence. The evidence must be direct. Again, oral evidence need not necessarily be by verbal expression, but also made by any method by which the witness is capable of making. A witness who cannot speak may communicate his knowledge of the facts to the court by signs or by writing, and in either case it will be regarded as oral evidence. It may be made by any method by which the witness is capable of making it. If the evidence refers to a fact which could be felt by any of the five senses, then it should be the evidence of a person who personally perceived it by that sense. Lastly, most of the criminal cases are mainly decided by oral evidence. Next is documentary evidence. A document means any matter expressed or described upon any substance by means of letters, figures, or marks, or by more than one of those means intended to be used, or which may be used for the purpose of recording that matter. Here, the document should be evidentiary or informative in its character. It must be something which the court can see or read for itself. Therefore, a recorded voice cannot be regarded as document. Documentary evidence means using of a document as evidence before the court of law. It also means anything or matter which contains a permanent record of a relevant fact or effect in issue. Generally, The following are the three methods of proving the contents of a document. One is by producing the document itself, that is by primary evidence or documentary evidence. Or next is number two, by producing a copy of the document, or number three is by an oral account of the contents of a document given by a person who had seen the document in cases where the better evidence is not available. Again, the contents of a document may be proved either by the production of the original document, which is called primary evidence, or in certain cases by copies or all accounts of its contents, as referred earlier. The word document means anything which contains a permanent record of a relevant fact. Thus, so long as a document is in existence and is available, its contents must be proved by primary evidence. Documentary evidence may be classified as primary evidence, and secondary evidence, if the original document itself is produced in the court, it is called primary evidence. And if a copy of the document is produced in the court, it is called as secondary evidence. What are primary evidences? Primary evidence is the evidence which the law requires to be given first. It is the document itself produced in original for the inspection of the court. Where a document is executed, in several parts, each part is primary evidence of the document. Where a document is executed to counterparts, each counterpart is primary evidence as against the parties executing it. Further, where a number of documents are all made by one uniform process, as in the case of printing, lithography, or photography. Each is primary evidence of the contents of the rest, but where they are all copies of a common original, they are not primary evidence of the contents of the original. In the Evidence Act, for the purpose of providing or disapproving effect, it requires that a document must be proved by its primary evidence. However, under certain circumstances, a document may be proved by secondary evidence. What are secondary evidences? Secondary evidence means certified copies or copies made from the original by mechanical processes, or copies made from a compared. Copies made from or compared with the original. Thus, if a copy of the document is produced in the court, it is called as secondary evidence. In law, secondary evidence means and includes the following: certified copies given under the provisions of the Act, copies made from the original by mechanical process, which in themselves ensure the accuracy of the book copy, and copies compared with such copies, copies made from or compared with the original. Next is counterparts of documents as against the parties who did not execute them. And next, number 5 is all accounts of the contents of a document given by some person who has himself seen it. A party who wants to give secondary evidence of a document on any one of the grounds stated above will have to prove that fact. then the court will treat it as the secondary evidence. Therefore, only under certain circumstances a document may be proved as secondary evidence. Direct evidence. All evidence can be classified as direct evidence or circumstantial evidence. Direct evidence means any fact which without the intervention of any other fact proves the existence of a fact in issue. Thus, if a fact cannot be proved without directly the help of any other fact, then it is called direct evidence. In other words, if a person who actually saw the incident gives evidence about the incident, then it is called direct evidence. Circumstantial evidence. The term circumstantial evidence has not been defined in the evidence. Has not been defined in the Evidence Act, but evidence is either direct or circumstantial. Circumstantial evidence is that which tends to establish the fact in issue by providing another fact, which though does not itself conclusively establish that fact. Circumstantial evidence sometimes speak as forcefully as the direct evidence, as in very few cases, direct evidence of the facts is available. Happen suddenly. Facts which happen suddenly do not leave behind much direct evidence. In that case, the main event will have to be reconstructed before the court with the help of the surrounding circumstances, such as the cause or the effect of event. Thus, circumstantial evidence is a fact from which the truth of another fact can be inferred with the help of intervening factors. The 5 golden principles which constitutes the proof of a case, evidence are as follows. One is the circumstances from which the conclusion of guilt is to be drawn should be fully established. Next, number 2 is the facts so established should be consistent only with the hypothesis of the guilt of the accused. That is to say, they should not be explainable or any other hypothesis except that the accused is guilty. Next, number 3 is the circumstances should be of a conclusive nature and tendency. For which they should exclude every possible hypothesis except the one to be proved. And next 5 is there must be a chain of evidence to complete as not to leave any reasonable ground for the conclusion consistent with the innocence of the accused, and must show that in all human probabilities the act must have been done by the accused. Therefore, the above conditions must be fulfilled before a case against an accused can be said to be fully established by circumstantial evidence. Further, in case if there is direct evidence and also circumstantial evidence, it is safe for the court to find an accused person guilty. Hearsay evidence. Hearsay evidence may be defined as that which a evidence which does not say of his own knowledge, but says that another has said or signified to him. In the law of evidence, hearsay evidence is not admissible. In the act, the principle is that the best evidence must be direct, and also the original documents must be produced to prove the existence, contents, and conditions thereof. Only in some exceptional cases, secondary evidence is admissible by the court. In hearsay evidence, a witness states not on the basis of what he himself saw or heard or what has come under of his bodily senses, but what he has learned through the medium of a third person. The evidence means and concludes. One is a statement made by a person not called as a witness, to which a statement contained or recorded in any book, documents or record whatever, proof of which is not admissible on other grounds. In very few exceptions to the hearsay rule, generally there is some special necessity. There is some special necessity for the admission of such evidence and some guarantee of its credibility. Therefore, hearsay evidence is an evidence given by a person who heard from others about the matter in dispute. It is not an evidence, and the court will not accept the hearsay evidence. Extrajudicial confession. An extrajudicial confession is admissible in evidence under Section 21 of the Evidence Act. It is that confession which is elsewhere than before a magistrate or in the court. Again, it is provided by the witnesses who heard the speaker's word constituting the confession. It may properly be made to any person or collection or body of persons, should not be acted upon unless it is proved by evidence of a most reliable character. Generally an extrajudicial confession really partakes the character of direct evidence rather than that of circumstantial evidence. The grounds of rejection as well as reception of extrajudicial confession are as follows. One is confessional constitutes the best evidence, as a person may be reasonably assumed not to admit facts detrimental to his interest. Two is they may also retard the progress of justice, as there is simple scope for abuse in the hands of unscrupulous witnesses, overzealous officers of the state, and in exceptional cases of the accused themselves, dominated by the idea of self-immolation, actuated by design or hallucination or even mental defects. Next, number 3 is they can be made under deception and artifice and obtained in consequence of deception practiced upon the accused. Next, number 4 is they can be made when the accused is drunk on in answer to questions which the accused need not have answered, or even the accused is warned that he is not bound to make such a confession. These confessions are frequently made in the presence of a person in authority, and while that circumstance makes it necessary for the court to scrutinize the evidence and circumstances carefully in order to ascertain whether the confession was voluntarily made, it is impossible to hold on the basis of that circumstance alone that the confession was not freely made. Admission and confession. Admission is a statement given by one person admitting the fact in disputes, but confession is a statement given by an accused admitting the offense committed by him. Next is examination of witnesses. A witness may be defined as a person. A witness may be defined as a person who gives evidence to a court. Witnesses and documents are placed before the court to prove a fact. Every witness is first examined by the party who has called him, and this is known as examination in chief. Witness by the party who summoned him to give evidence. It is on strictly relevant facts only. Again, it may not be based on leading questions. The examination of the witness by opposite party's counsel is called cross-examination. The examination of the witness by the opposite party's counsel is called cross-examination. Here the main object is the eliciting of information concerning facts in issue favorable to the party on whose behalf it is conducted, and the throwing of doubt on the accuracy of evidence given against that party. It is one of the greatest modern weapons of testing the variety of a statement made by a person. It is a powerful engine. It is likewise an extremely dangerous one, very apt to recoil even on those who know how to use it. In other words, it is both a sword of attack and a shield of defense. As such, it is a two-edged weapon. Here the success or failure of a party depends very much upon the skillful manner in which it is conducted on his behalf. Re-examination. It is the examination of a witness subsequent to the cross-examination by the party who called him. It is meant for the demonstration of the real meaning of the evidence arising in cross-examination used in the cross-examination. Therefore, the chief object of it is to give the witness an opportunity to explain what he said in cross-examination. Next is leading question. Any question suggesting the answer which the person putting it wishes or expects to receive is called a leading question. It is allowed in cross-examination, but not in examination in chief or re-examination. A leading question is thus a question which suggests to the witness the answer he is expected to make. It puts the answer in the mouth of the witness, and all that he had to do is to throw it back. As such, it may be stated as one to put to a witness which suggests the desired answer, or puts the answer into the mouth and puts the answer into his mouth, or in the case of disputed matter, permits only the reply yes or no. Dying declaration. A dying declaration is a statement, written or verbal, made by a person as to the cause of his death or as the circumstances of the transaction which resulted in his death. In case of homicide, statements made by a person since deceased are admissible to prove the cause and circumstances of the man's death. Any statements made by a dying person as to the injuries which have brought him or her to that condition or the circumstances under which those injuries came to be inflicted are called dying declaration. Before a dying declaration can be admitted in evidence, it must be proved that one such statement is made by a person since deceased as to the cause of his death or as to any of the circumstances of the transaction which resulted in his death. And next, number 2 is the cause of that person's death is in question. A dying declaration is admissible. A dying declaration is admissible, whether it has been reduced to writing or not. But the statement must relate to the injuries which have brought him or her to that condition or the circumstances under which those injuries came to be inflicted. This statement must be made when he is dying from the result of injury which causes his death. Otherwise, it is not a dying declaration. However, a statement made by the deceased several days after the occurrence resulting in his death is not a dying declaration. Proving handwriting of a person. The handwriting of a person may be proved in any one of the following methods. One is by the direct evidence of the writer himself. 2 is by the evidence of experts in comparing the handwriting in question with the approved writing. 3 is by the evidence of a person who is acquainted with the handwriting of a person whose handwriting is in question. A person gets opportunity to be acquainted with the handwriting of another person when he has often seen that person writing something or when he has been receiving papers written by that person in reply to his own draft or for the purpose of typing or filing or advising. Naturally, the opinion of such a person can be relied upon. Next, number 4 is by comparing the handwriting which is admitted or proved to be the handwriting of the person in question. Here the court made a person present in the court to write any words or figures for the purpose of enabling the court to compare them with the writing in question. And next is number 5, by evidence of a person in whose presence that particular document was written. Thus, if a document is alleged to be signed or to have been written wholly or in part by any person, the signature or the handwriting, the signature or the handwriting of so much of the document as is alleged to be in that person's handwriting must be proved to be in his handwriting. Again, the party who produces a document which he alleged is exulting, which he alleges is exalted, signed as written by a certain person, has to prove that fact. Presumption, where facts are not proved directly, but are inferred with more or less probability from facts that have been so proved. The inference is called a presumption of facts or presumption hominis. It is an inference of the existence of some facts which is drawn without evidence from some other facts already proved or assumed to exist. In other words, a presumption is an inference affirmative or disaffirmative of the existence of some fact drawn by a judicial tribunal by a process of probable reasoning from some matter of fact, either judicially noticed or admitted or established by legal evidence to the satisfaction of the court. presumptions are of two kinds. Presumptions are of two kinds, such as presumption of fact and of law. The former relates to physical facts and the latter to psychological facts. Presumption of fact are references logically drawn from one fact as to the existence of other facts. Again, presumptions of fact are refutable by evidence to the contrary. It also means a rule of law that the courts and the judges should draw a particular evidence. Unless and until the truth of such inference is disproved, as such all presumptions of a fact are rebutable, whereas presumptions of law may be either irrefutable so that no evidence to the contrary may be given or rebuted. They are conclusive presumptions against which no amount of evidence can be abducted. No amount of evidence can be abused to disapprove them. The presumptions of law are called irrefutable presumptions of law. They are of compulsory nature. A refutable presumption of law is a legal rule to be applied by the court in the absence of conflicting evidence. However, the law allows courts to presume certain facts and the party need not give evidence thereof. The court in certain cases assumes the fact to exist or not to exist from the evidence in respect of other facts. Again, the presumptions of facts are inference, which are naturally and logically drawn from the experience and observation of the course of nature. The constitution of human mind, the springs of human action, the usages and habits of society, and order course of human affairs. Added to this, it is not obligatory for the court to draw a presumption of facts. In respect of such presumption, the Act allows the judge a discretion in each case to decide whether the fact which may be presumed has been proved by virtue of that presumptions, but presumption of law or artificial presumptions are inferences or prepositions established by law. Presumptions of law are based, like presumptions of fact, on the uniformity of deduction which experience proves to be justifiable. Presumption of mixed law and fact hold an intermediate place between presumptions of law and presumptions of fact and are called mixed presumptions. They consist chiefly of certain inference which from their strength, importance, or frequent occurrence are take, as it were, the observation of the law and from being consistently recommended by judges and acted or by injuries, become in time as familiar to the court as presumptions of law and occupy nearly as important a place in the administration and occupy nearly as importance a place in the administration of justice. Lastly, a presumption is a rule which treats an unknown fact as proved on proof or admission of certain facts. Presumption is not proof. Proof is the result of evidence. Admissions, presumptions, facts which are judicially noticed and other matters. Estoppel is a principle of law by which a person is held bound by the representations made by him or arising out of his conduct. It is a rule of evidence which precludes a party from gainsaying the truth of certain facts. Principle of estoppel prevents a person or stops him from denying the particular fact which he or she had already represented to be true. Further, in a rule of evidence, estoppel means where a person is precluded or estopped from denying the existence of a state of things which has been previously asserted to exist by him or her, or which by words or conduct he or she has induced another to believe in and to act upon. For illustration, sapna, intentionally and falsely leads Sudra to believe that. Falsely leads Subhra to believe that a house belongs to Sapna and thereby induces Subhra to buy and pay for it. The house afterwards becomes the property of Subhra, and Sapna choose to set aside the sale on the ground that at the time of the sale she had no title. In this case, she will not be allowed to prove her want of title. The following three essentials must be satisfied to create an estoppel. One is there must have been some declaration, act or omission on the part of one person intentionally causing or permitting another person to believe a thing to be true. Next, number two is the person to whom the representation is made must believe that to be true. Third is there must be some act in pursuance of that behalf. There must be some act in pursuance of the belief. The rule of estoppel is based on equity and good conscience. In other words, a person alleging contradictory facts should not be heard. Again, the representation, which is the basis for the rule of estoppel, must be clear and unambiguous and not indefinite. The representation also may be expressed or implied, means it may consist either declaration, act or omission. Estoppels are generally divided into three kinds. One is by deed, which binds the parties to instrument and those claiming through them to its statements. Two is by conduct, where a person must be record or conduct, induce another to believe that a certain state of things exists and to cause that other person to act on that belief which he otherwise would not have done. Three is by record, which means it is the results from the judgment of a competent court. It is chiefly concerned with the effect of judgment and its admissibility in evidence. However, in India, estoppel by deed does not exist. as told by judgment or the rule of res judicata is not a rule of pure procedure and is thus not given in the act except with reference to the relevancy of judgment. They come into application only in civil cases. Therefore, the principle of estoppel is that when a person by his words, whether written or spoken, or by his conduct makes a representation that a certain state of thing is true and the other person relying upon the truth or representation alters his position, the person making the representation will be estopped from denying the truth. To sum up, estopped is an exclusionary rule of evidence, the application of which may result in a parties being prohibited from asserting or denying some facts. However, there can be no estoppel against the provision of a statute. Dear friends, brothers and sisters, scholars, learners, those who are studying in LLB, they are preparing their examination fundamentally. So for their general guidance and general consultancy, they must listen. Our next topic is interpretation of statutes. Interpretation of statutes. What's the nature and scope? The law, howsoever rigid it may be, has to be interpreted in a flexible manner so as to see that the rule of law is not abrogated. A statute is the will of the legislation, and an Indian statute is an act of the central legislature or of a state legislature. It includes act passed by imperial or provincial legislatures in pre-independence days, as well as regulations. In interpreting or constructing a statute, the obvious method would be to start with the literal interpretation. But then, what is the literal meaning of a word? What is the ordinary plain meaning we give to words? Therefore, the first rule that judges have laid down is that the words of an enactment are to be given their literal meaning, and if such meaning is clear and unambiguous, effect should be given to a provision of a statute, whatever may be the consequences. The process by which one tries to understand the intention of the legislature to the letter of the enactment is called interpretation. It is the process by which the court seeks to ascertain the meaning of a particular legislation. The object of all interpretation of a statute is to determine what intention is conveyed either expressly or impliedly by the language used so far as is necessary for determining whether a particular case or state of the facts presented to the interpreter falls within it. This means the real object of it is to unfold the ambiguous words and expression and to resolve the inconsistencies. The real function of the judge in administering statute law is twofold. One is to discover the facts of the case, and then two is to discover how the legislature intends him to act in such circumstances. The legislature, while enacting a statute, could not foresee all the cases and make its intention clear so as to make it applicable to all of them. Therefore, multi-million question arises whether the judge in such cases confines himself within the four walls of the Act or go on a voyage of discovery and modify the sole meaning of the word where an apparent absurdity, hardship or injustice will be caused. Judge in this creative phase of statutory interpretation must discover the facts needed as the basis of action in such sources as the hearing and reports of investigatory committees and commissions and the records of legislative proceedings and debates. Kinds of interpretation. Interpretation is of two kinds, literal or grammatical and logical. The former deals exclusively with the verbal expression of law. The latter deals with a free interpretation and a departure from the letter of law. Literal or grammatical interpretation for the administration of justice. A judge has to comprehend the real meaning of the statute. If judges are allowed to overlook the script, a legislation is apt to lose its significance. As such, literal interpretation is the normal rule. The law lies in its spirit and not in its letter. Thus, in construing statutes, the cardinal rule is to construe its provisions, literally and grammatically giving the words their ordinary and natural meaning. In order to determine the plain meaning of the statute, the court may make use of various rules of interpretation. However, the first and primary rule of construction is that the intention of the legislature must be found in the words used by the legislature itself. If the words used are capable of one construction only, then it would not be open to the courts to adopt any hypothetical construction on the ground that such hypothetical construction is more consistent with the alleged object and policy of the Act. Thus, it is a cardinal rule of interpretation of statute that statutory expressions should be interpreted in their primary and ordinary sense. When the words provide a clear, unambiguous meaning, the courts of law are not entitled to read something more in those words than what is contained in them. Further, in the absence of anything in the Act itself to indicate that the apparent intention of the section is not the real intention, the court would not justify in reading into those provisions a meaning which on a plain interpretation they are incapable of bearing. Therefore, the court has to consider the meaning attributed to the particular word in question when it was enacted. Logical interpretation. What is logical interpretation? If there is defect in the letter of enactment, such as ambiguity or inconsistency or omission, literal interpretation is inadequate and logical interpretation should be used. In this kind of interpretation, a departure from the letter of the law occurs and it goes behind the language used in the statute for the ascertainment of its meaning and adhered to when grammatical interpretation leads to some absurdity or inconsistency. In such cases, it is the duty of the court to discover and give effect to the true intention of the legislature. Here, there are two exceptions to the general rule that the language used in a statute must be constructed in its grammatical sense and taken as conclusive. The first of these is where the letter of the law is logically defective and fails to give a definite, coherent and complete idea. The second is where the text leads to a result so unreasonable that it is clear that the legislature could not have meant what it had said. Clerical error in the text or reference to a section by the wrong number or omission of a negative in some passage in which it is clearly required furnish examples of the second type of cases. Methods of interpretation. There are three different methods of interpretation, such as one is the literal or plain meaning rule, two is the golden rule, and number three is the mischief rule. Literal or plain meaning rule. If the precise words used are plain and unambiguous, we are bound to construe them in their ordinary sense, even though it do lead, in our view of the case, to an absurdity or manifest injustice. According to R.W.M. Dice, that there is in the first place an unfortunate tendency to imagine that the courts are thereby giving effect to the intention of Parliament on the hypothesis that the words themselves do, in such a case, best declare the intention of the lawgiver. But it would seem that whenever the literal rule is applied, any reference to the intention of Parliament is later avoided. Secondly, the plain meaning rule suffers from the inherent weakness. That is, it is not always easy to say whether a word is plain or not. Thus, the literal rule, in this opinion, needs to be understood subject to the following 5 exemplary explanatory riders. One is the statute may itself provide a special meaning for a term, which is usually to be found in the interpretation section. Two is technical words are given their ordinary technical meaning. If the statute has not specified any other, his words will not be inserted by implication, for his words undergo shift in meaning in the course of time. 5 is finally, and by no means the least, it should always be remembered that words acquire significance from their context. Next is golden rule. The golden rule departs from the strictly literal rule in as much as according to the literal rule. The plain meaning has to be adhered to even to the extent of absurdity. The golden rule of interpretation adopted in English law is that in constructing statutes and all written instruments, the grammatical and ordinary sense of the words is to be adhered to unless they would lead to some absurdity or some repugnance or inconsistency, but no further. Thus, it is no doubt true that it is not the function of the court to fill in gaps and omissions, but in exceptional cases, the courts have to perform this function in accordance with the golden rule of interpretation. Again, to apply the words literally is to defeat the obvious intention of the legislature and to produce a wholly unreasonable result. To achieve the obvious intention and to produce a reasonable result, we must do some violence to the words. Mischief rule. It is obvious that an enactment without a purpose or social objective will be nonsense. Thus, the enactment must be read in the light of such assumed purpose, for then only will it make sense, and the court will also be doing its duty of merging the enactment into the general system of law, taking into account its policy. As such, it is the duty of the judge to make such construction of a statute as shall suppress the mischief and advance the remedy. In other words, it is a sound rule of interpretation that a statute should be so constructed as to prevent the mischief and advance the remedy according to the real intention of the mistake of the makers. All the above three rules have resulted from two main approaches in literal or plain meaning. In literal or plain meaning rule and golden rule, it is referential approach, and in mischief rule, it is purposive approach. However, ordinarily, the courts must follow literal unless there are adequate reasons to follow the logical interpretation. Limitations to interpretation of statutes. Any interpretation must be done to aid and not to frustrate the legislative policy and administrative decisions. Again, for the interpretation of all statutes, four important things must be taken into consideration. One is what was the prior law. Two is what was the mischief or defect for which it did not provide. Three is what remedy legislature resolved therefore. And four is the reason of the remedy. Lastly, interpretation is the process by which the court seeks to ascertain the meaning of a particular legislation. It is the meaning of a fact. Therefore, in the matter of interpretation of a statute, the courts are not free to put their own interpretation on the statute for the purpose of removing anomalies. This is the function of legislature. The courts are required to interpret the statutes as they are, and if there is no ambiguity in the language used, effect must be given to the clear terms of statutes. The second limitation on the courts is that the interpretation by the court of the statute is in any particular manner should not render any part of it odious. As referred earlier, that a statute is the will of the legislature and the fundamental rule of interpretation to which all others are subordinate is that a statute is to be expounded according to the intent of those that made it. It is an elementary rule that a thing which is within the title of a statute will generally be constructed as not within the statute unless it be also within the real intention of the legislature and the words. If sufficiently flexible, it must be constructed in the sense which, if less correct grammatically, is more in harmony with that intention. When alternative constructions are equally open, that alternative is to be chosen which will be consistent with the smooth working of the system which the statute purports to be regulating, and that alternative is to be rejected which will introduce uncertainty, friction or confusion into the working of the system. One is to arrive at the real meaning. It is always necessary to get an exact conception of the aim, scope and object of the whole act. Next, number 2 is to consider what was the law before the act was passed. What was the mischief and effect for which the law had not provided, what remedy Parliament has appointed, and the reason of the remedy. Having said this, we ought to give an act the plain, fair and literal meaning of its words, where we do not see from its scope that such meaning would be inconsistent or would lead to manifold injustice. In constructing statutes, the grammatical and ordinary sense of the words is to be adhered to unless that would lead to absurdity or some repugnancy or inconsistency with the use of the instruments, in which case the grammatical and ordinary sense of the words may be modified so as to avoid that absurdity, repugnancy or inconsistency, but no further. It is the cardinal rule governing the interpretation of statute that when the language of the legislature admit of two constructions, the courts should not adopt a construction leading to absurdity or obvious injustice. The court shall struggle against repugnancy and should construe an enactment as far as possible in accordance with the terms of the other statute which it does not expressly modify or repeal. Generally, a statute ought to be so constructed that if it can be prevented, no clause, sentence or word shall be superfluous, void and insignificant. In case where there is ambiguity in the language used by the legislature or where more than one construction is possible, then the rule framed under the Act would help the court in coming to the right conclusion as to the construction which should be placed upon a particular provision in the Act. But where alternative constructions are equally open, that alternative is to be chosen which will be consistent with the smooth working of the system which the statute purports to be regulating, and that alternative is to be rejected which will introduce uncertainty, friction or confusion into the working of the system. Dear friends, scholars, learners, brothers and sisters, all of you are listening. Very important topic for the general awareness about legal rules and regulations. Law library. Like any other library, a law library is a trinity of man, materials and building. As a law library contains highly specialized materials also, it requires special skill to handle. Basically, legal materials consist of statutory law and reports of decided cases. Any law library has to be well equipped with regard to these basic materials. Legislative materials. The legislative materials that are act, rules, notifications, orders, etc. are published in the Gazette of India. All sections of the Gazette need not be looked through. Only Part 1, Section 1 and Part 2, Section 1 to 4. Acts. For acts, the official publications are Indian Code. This is the official publication containing the acts in force in India without commentaries. This is kept up to date by issuing correction slips from time to time. Number 2 is Acts of Parliament. This is an official annual publication containing all the bare acts passed in a particular year. Next is private publications. There are many private publications which are brought out at regular intervals and contain the central as well as the state legislative materials. The most popular of them is the All India Reporter, AIR, which has a section containing acts passed by Parliament. Next is AIR Manual. In this one can find all the acts passed by Parliament and which are still in force. The arrangement of alphabetically AIR Manual has several good features. One is in the footnotes under each section of the act relevant case law has been given. 2 is every act begins with the settlement of its objects and reasons. 3 is statutes allied to the act have been given in the beginning. And 4 is references have been made of the earlier amendments and also the state amendments, if any. Next is Civil Court Manual. Arrangement is the same as in AIR Manual. Only difference is that it contains only civil acts and not criminal acts. Rules, orders and notifications. All the statutory and non-statutory rules, orders and notifications issued by the Government of India and the state government are published in the official gazettes. In addition to the gazette, there are the following materials: general statutory rules and orders. This is the official publication of all the rules, orders and notification issued by the central government. The arrangement is subject-wise, that are, the material has been arranged on the basis of the subjects of the parent acts under which the rules have been framed. Rules framed by judiciary. The Supreme Court and the High Court frame their own rules. These are published and revised from time to time. Legislative material of the States Act. Officials or private gadgets of Orissa Acts, rules, orders, notification. Gazette of Orissa Laws Manual, Orissa Law Notes, Orissa Law General, Orissa Law Times. Orissa Law Times means Act. Judicial material. Judicial material includes judgment of the Supreme Court and High Court. Official reports. Supreme Court reports, SCR. This is a monthly reporting cases decided by the Supreme Court. Indian law reports, ILR. These are the official publications for the state high court. They are published monthly. Private reports. The most popular of the private law reports is the All India Reporter. It is published monthly and reports cases and the High Court. These are law reports exclusively devoted to the Supreme Court cases such as Supreme Court Journalist, Madras Law Journal, Bombay Law Reporter, and Calcutta Weekly Notes. Specialized law reports. These law reports specialize in cases related to particular branches of law. They report cases decided by the Supreme Court, High Courts, and tribunals. They are labor and industrial cases, LAB, IC, Criminal Law Journal, Criminal LJ, Income Tax Reports, ITR, and company cases, CC. Digest. The main function of the digest is to refer to all the reported cases on a particular subject. The most widely used one is Yearly Digest, a monthly published by the Madras Law Journal Limited. Cases are grouped and listed under the title of the act concerned, a summary of the facts, the points involved, and the final decision is given. Further, the citations of all the relevant reports are listed. AIR Limited have also published digest of the case law. Thus, there are 50 years digest, 1901 to 1950, 15 years digest, 1976 to 90, and quinennial digest covering the periods 1976 to 80, 81 to 85, 86 to 90, etc. There are also digests of cases relating to particular subjects such as labor law digest, company law digest, and income tax digest, etc. Next is index. A problem may arise as to how to locate an article or case comment relating to a particular topic. One way to use our periodicals is to refer the cumulative indexes. They are helpful as one need not go through each and every volume. In the cumulative index, all the material is listed, author-wise as well as subject-wise. Another source of collecting material on the particular topic from the periodicals is the indexes covering all the periodicals. These are indexed to Indian legal periodicals. One is Index to Indian legal periodicals. 2 is index to legal periodicals. 3 is index to foreign legal periodicals. The first covers Indian periodicals alone. The second and third are complementary as the countries not covered by the index to legal periodicals are covered by the index or foreign legal periodicals. Thus, two indexes taken together cover the whole world. The articles are arranged subject-wise. Encyclopedia. Encyclopedia is a book or set of books containing articles on various topics, usually in an alphabetical arrangement, covering all branches of knowledge or, less commonly, all aspects of one subject. Examples of these are: one is Encyclopedia Britannica, two is Encyclopedia Americana, third is International Encyclopedia of the Social Sciences. Legal encyclopedias. The contents of the legal encyclopedias are also arranged in the same manner as in general encyclopedias. They are the treasure house of knowledge on various subjects. The entire law is divided into different legal topics. Thus, the arrangement in these books is according to topics given by in alphabetical order. It is important, therefore, that one should be familiar with the topical scheme of the set. That is, a particular subject may fall under one or the other topic. Generally, a list of topics is given in the first volume of the set. This list has to be gone through first to ascertain as to under what topic the subject of one research can be found. After this, the researcher should take out that particular volume in which that subject has been dealt with. One of the important sets of legal encyclopedias is the Halsbury's Laws of England. This is a widely used legal encyclopedia giving detailed and up-to-date account of the law on a particular subject. To keep the set up to date, new edition and cumulative supplements are issued every year. Popular law magazines. In addition to legal periodicals, there are law magazines dealing with current legal problems. These magazines contain articles meant not for lawyers only, but also for law students and general public. One of the important sets of legal encyclopedias is the Halsbury's Laws of England. This is a widely used legal encyclopedia giving detailed and up-to-date account of the law on a particular subject. To keep new edition and cumulative supplements are issued every year. Popular law magazines. In addition to legal periodicals, there are law magazines dealing with current legal problems. These magazines contain articles meant not for lawyers only, but also for law students and the general public. They play an important role in spreading legal awareness. Important law magazines are the Lawyers Collective, Lex et Juris, the law magazines, and etc. Some magazines are published in a regional language also. The important law magazines in Korea is Sarpanch, published by the Legal Miscellaneous, Katak, Odisha. Important periodicals and abbreviations. Times Journal, AIR All India Reporter, ASIL Annual Survey of Indian Law, ATC Administrative Tribunal cases, ACLR Academy, Law Review, All ER, All England Law Reports, BOMB-LR, Bombay Law Reporter, CCC, Current Civil Cases, CLT, Cuttack Law Times, CMLJ, Civil and Military Law Journal, CULR, Cochin University Law Review, CWN, Calcutta Weekly Notice, Calcutta Weekly Notes, COMIR, Comparative Law Review, CRLJ, Criminal Law Journal, Harvard Law Review, IA Indian Advocate. IA stands for Indian Advocate. IB Review, Indian Bar Review. IJR, Indian Judicial Reports. IJ Legal Students, Indian Journal of Legal Studies. ITR, Indian Law Reports. ILR Review, Indian Law Review. ITR, Indian Tax Reports. JBCI, Journal of Bar Council of India. JILI, Journal of Indian Law Institute. LLJ, Labor Law Journal. LQR, Law Quietly Review. Lab IC, Labor and Industrial Cases. MLJ, Madras Law Journal. MLR, Modern Law Review. OJD, Orissa Judicial Decision. OCR, Orissa Criminal Reports. SCC, Supreme Court Cases. SCJ, Supreme Court Journal. SCR, Supreme Court Report. SLJ, Service Law Journal. YLJ, Yale Law Journal. Explanation of citations and differences. Sapna versus Subra, AIR 1995, Orissa 4. This is a citation of a case. Here Sapna is the petitioner or appellant and Subra is the respondent. The case is decided by the Orissa High Court and is reported in the year 1995 in All India Reporters at page 420. Case number 2 is Sasanka versus Sanjeev, 1995, 3 SCC 210. This is the citation of the case. Here Susanka is the petitioner or appellant and Sanjeev is the respondent. The case is decided by the Supreme Court and reported in Supreme Court cases published in 1995. The case is reported at page number 210. Next is Sri Kanta Misra, Adoptions Among Us, JBCI 110, 1988. This is the citation of the article. The title of the article is Adoptions Among Us Mohammedans. Adoptions Among Us Mohammedans. It is written by Sri Kanta Misra. The article is published in the volume of the Journal of the Bar Council of India, New Delhi at page 110 to 116 in the year 1988. Sri Kanta Misra, Human Rights, a fundamental issue. JBCI 97 to 144. This is a citation of an article. The title of the article is Human Rights, a fundamental issue. It is written by Kanta Misra. The article is published in the volume of the Journal of the Bar Council of India, New Delhi at page 97 to 104 in the year 1993. Shri Kanta Misra, Legal Profession in India, Some Random Facts and Facets, 1991, Triple C, New Delhi, July 285 to 289. This is the citation of an article. The title of the article is Legal Profession in India, Some Random Facts and Facets. It is written by Sri Kanta Misra and published at pages 285 to 289 in the General section of Current Civil Cases, Delhi in the year 1991. Law and Lawyers, 1919, SEZ, Allahabad, Journal 11 to 12. This is a citation of an article. The title of the article is Law and Lawyers. It is written by Shrikanta Misra and published at pages 11 to 12 in the Journal section of the Supreme Court, Journal Allahabad in the year 1919. Shrikanta Misra marries in Odisha, Rites and Rituals in B.S. Das, Glimpses of Odisha 234, Punchi Pustak, Calcutta 1986. The reference here is to an article written by Shrikanta Misra. The title of the article is Marriage in Odisha, Rites and Rituals. It is published at page 300 of a book Glimpses of Odisha edited by B.S. Das and published in 1986 by Putni Pustak, Calcutta. Shrikanta Misra, Modern Lahore, Modern Labour Laws and Industrial Relations and Bill Publication, New Delhi, 1992. This is the citation is a book. The title of the book is Modern Labour Laws and Industrial Relations. It is written by Shrikanta Misra. This reference is to the first edition of book published in 1992. Deep and Deep Publication, New Delhi is the publisher. Shrikanta Misra, Ancient Hindu Marriage Law and Practice, first edition, Deep and Deep Publication, New Delhi, 1994. This is the citation of a book. The title of the book is Ancient Hindu Marriage Law and Practice. It is written by Shrikanta Misra. The reference is to the first edition of the book published in 1994, Deep and Deep Publication, New Delhi is the publisher. Search of case law. Search of case law. There are many conventional methods to search the case law, but the foremost amongst them is that it enables search of case law through three approaches. One is statute approach, two is topic approach, and three is case method approach. One is statute approach. This is the traditional approach. This is the traditional approach. This is the traditional approach to search by the name of the statute, rule, regulation or order, central or state, and then by the number of the article, section, rule, regulation, para or schedule. Invariably, the desired case law would be found under its statute heading in the alphabetical order. If not, the cross references will show where such statute has been dealt with topic-wise under the topic approach. Next is topic approach. The topic approach is the most convenient and easy method of search. It is based on commonly used words and headings and has been used both for the non-statutory subjects like interpretation of statutes, practice and procedure, Hindu law, labor laws, criminal trial, administrative law, etc. In these large topics, topic-wise grouping, the statutory headings are found at the subtopic level, either with case law below them or with a cross reference to the relevant subtopic. Additionally, the synopsis lists also the statutes and subtopics covered under to locate the necessary precedents quickly and easily, even if somebody is not familiar with a statute. Again, many concepts, doctrines, maxims, etc., whether part of any other topic or statute, have themselves been listed as independent topics. The topic, words and phrases abounds with minor topics and concepts. The synopsis below each topic also enables to quickly go to specific area of interest through a quick review of all the subtopic headings given in the synopsis. To facilitate quick search by the synopsis heading, such a synopsis heading with its number is generally printed on the top of the left column of all subsequent left hand pages where the topic has been dealt with. Next is case method approach. Search can be done through the case method from any known case of the court. This method will also work for privy council, high court and foreign cases. If they have been cited in any cases, the second important use of the case method approach is for rechecking. This recheck is required with two objectives in mind. One is to know if there are any later rulings on the subjects, and two is to know the standing statutes of the case selected and sought to be used, namely whether that case has been relied, followed or applied in later cases, thereby improving its standing as it has been distinguished, limited or overruled, thereby adversely affecting its standing. Which information can be treated in cases when explained in a later case, help in understanding of the scope and application of the ruling. All the above three approaches have their own advantages and help not only to find the relevant case law but to find the entire and latest case law so as not to leave out any relevant case of the court. Having submitted the above, the author would like to state here that today most of the PG department law teachers in the university in India stands on the lowest and narrowest academic platform concerning the knowledge base. They have little intellectual curiosity, no way of learning. They are not disturbed by any BA preaching question, not diverted by uncommon ideas, not stimulated by independently derived hypotheses. The result is that after spending empty years of experience, they settle down in life largely as an unproductive agent. Thus, they do not grow properly during their academic career. Educational institutions are expected to accelerate the process of social transformation. The continuous academic growth of the teaching faculty is one of the professional responsibilities. As such, each one of us should be accountable to the profession. No worthwhile research book is published today without an acknowledgement of help from a library and librarian. A teacher may teach only a specific subject, while a librarian can impart skills, reading ability, research methods, literature survey, etc., which scholars urgently need today in colleges and research institutions. If librarians master just a few books on learning skills, they can organize and conduct much needed special classes in colleges, which most of the scholars shall be, because they cannot get such vital stuff from their specialists. No scope for success in modern times if a librarian has taken an oath of not doing the needed general reading himself or herself. Therefore, the librarians must do reading, because knowledge is their stock in trade. Failing this, India shall not enter into the information age further. He should develop an eye for finding out major gaps in vital general legal literature and should try to get it filed either through the self or by others. Dear friends, all of you are listening about the law. Next topic we will read tomorrow, Introduction to Legal Writing. So for up to that time, you are to prepare your fundamentals for the general awareness and general guidance, introduction, information, instructions regarding the law. Dear friends, thanks for your presence. आज अब और यहाँ हमारे इस भारतवर्ष में वो महान परिवर्तन जो भारतीय संस्कृति को ऊपर उठाने के लिए और हमारे आजादी प्रदान करने वाले नेताजी सुभाष चंद्र बोस हमारे धन्यवाद।